Thanks for joining. I'm Tom Cavenagh. I am professor of business law and conflict resolution at North Central College and Schneller Sisters Professor of leadership ethics and values. I direct our leadership ethics and values program, and I've been at the college for 31 years. It's been a wonderful experience and a great opportunity. I practiced corporate director and officer defense law prior to joining the faculty all those years ago. And now I teach business law, conflict resolution, and leadership courses. My special loves, and you'll see that as we move through this, are the Constitution and the Supreme Court, both of which have become very significant in this COVID and the Constitution era. I'm going to try and cover a pretty fair amount of material this morning. Let me slide that over here. But let's just say a couple quick things by way of introduction. I'm recording this on July 8th. I think as all of you are watching the news, you're seeing that the longer we wait, the more this virus seems to grow. There are currently spikes, as everybody knows. There are moves to slow or end reopening in some states. And a couple of additional things that I think are relevant as we think about the law here. First, there is clearly increasing resistance to continued government regulation or oversight here. More and more people are more and more frustrated. I'm not going to comment on whether they should be or not, with the range of ways that their lives are being changed. Second, and related to the first, there's a diminishing compliance with government regulations. Anybody watching this short webinar, I think, will have seen people on beaches without masks and wide coverage of ignoring is a strong word, but certainly skirting the boundaries of government regulation and rules here. I'm struck as I do this that two of the sort of foundational ways Americans think about themselves and their lives, hugely optimistic, but very much committed to autonomy, are relative to the virus, I think, a double-edged sword. These things may get us through, that is to say, being optimistic, uh, exercising autonomy, doing our research, but at the same time, they are contributing to that, as I earlier said, diminishing compliance sort of thing. So let's talk about what our format will be, what I'd like to cover today. First, four first things, as I do, and maybe this is the first. This is the best thing in the world and the worst thing in the world presentation. I thought about making that my subtitle. The best thing in the world, the Constitution. The worst thing in the world, at least right now, this virus. So, second, let me say this. I'm not going to try and address the wisdom or propriety of any particular policy or rule or government plan in a federal, a state context, a governor, the president. Um, this is not the place to do that. What I will do, third, is to try and give you the legal groundwork, and in particular, some of the ways courts have thought about these kinds of questions, so you can make your own judgments about whether or not any particular policy or approach that government is taking to addressing the virus is a good one. My own view is that we've all been in a position where I think we've tried to say of one another, let's give everybody the benefit of the doubt. And I will tell you that I think that's largely the way courts have thought about this. Let's give people the benefit of the doubt as they try and do their best to stop this virus. However, the longer it goes and the more we know, I think the less latitude and deference courts will give, particularly to the executive branch of the federal and state governments to continue some of the things they're doing. Last, this is not our first pandemic. The Spanish flu in 1918 clearly was, and in a moment I'm going to say that the context in which the Constitution was written saw much illness. But I think it is important to point out that this is our first modern one. And so the presence of social media, the vastly increased capacity of technology, and in particular, we'll talk about in a moment, cell phones, makes this a first of its kind, even if it's not a first of this particular sort of thing. So that means that, and this is the final kind of first thing, the law is not clear on a number of these questions, and we are going to have to wait to see how legislatures rewrite statutes, and how the courts interpret them, both with respect to the continuing difficulties of the coronavirus and presumably future pandemics, as frightening as it is to say that out loud. I'm going to take up 5 things over the course of the next half hour or so. The first of which is to lay a little bit of context and to set out some basic constitutional and legal principles. Those, I hope, will let us talk about numbers 2, 3, 4, and 5, which are the coronavirus where you live, the coronavirus where you work, the coronavirus where you recreate, and I'm using some of those words kind of broadly here to capture some themes, and then a few thoughts about looking to the future. There's something sort of frightening about the idea that the coronavirus is everywhere, but maybe that's a good way of thinking about how hard it is to try and manage this from a legal perspective. So 4 points with respect to the constitutional context in which we're working, and I'll move the picture in a moment when I get to numbers 3 and 4. The first is to say this: the framers understood public health concerns. That is, from before the foundations of this republic, before the Constitution was written, there were significant public health difficulties in a country not yet developed, where the cities were ports. As we say here, malaria, yellow fever, typhoid, and cholera were rampant. So what we're experiencing today in terms of public health concerns is not something that wasn't present when the framers were trying to craft a new form of government in their constitution. Hamilton was quarantined, I think many of you will know, as he traveled as a result of a yellow fever scare. Cities and states at the time of the framing regularly closed themselves to others to keep out disease. Today's laws, I think it's important to say, reflect yesterday's problems. So we don't start from a blank slate when we start to think through the way the framers and then courts and legislatures since then have thought about public health. Second, the framers devised a system of government that satisfied both those seeking a powerful national government and those who preferred maintaining robust state rights. I'm guessing that virtually everybody listening knows the Federalist Papers and the debates that formed around these two questions. Do we want a federal government that has broad authority to legislate with respect to what states do? Or did we want a government, federal government that is, that respected state rights and that maintained a robust set of state rights? And I think everybody knows, as we get to number 3, that the genius of the framers was to create a federal government of limited and distributed power. So just consider for a moment the Bill of Rights, as I say here, which is a list of things government can't do, not necessarily a grant of power to the government. Now, it's important to say that in Articles 1, 2, and 3, the ways government was entitled to make itself powerful are described, and in particular, what the president, the Congress, and the courts could do is described. But in all of those descriptions, very significant leeway was given to states and state governments. So there's been some debate. Would we be better off with a much stronger central federal government that could dictate national policy relative to a pandemic? I think there are those that think the answer to that question is yes. We don't have one. And in a moment, I want to say a word about federalism. But at the time of the framing of the Constitution, the principal thing, well, maybe not the principal thing, but one of the principal things driving the framers' thinking was this: we escaped one king and we weren't going to create or coronate another one. So we settled on a system that distributed power across the federal government, state governments, and of course, not then, but now, county governments, city governments. And what you've seen as a result of that is this incredible range of regulations and rules that are being promulgated by mayors, governors, and to some extent, the president. So it's a complicated system. Finally, I want to just take one word from the Declaration of Independence. Let me move this so we can have a better view of number 4. And say that from our founding, we treated our fundamental rights, and we'll come to those a bit further on and a bit more robustly, as inalienable. I think one of the ways the framers would have thought about that, and I think that many of us do, is that first come rights, then comes government. Because if that's not the order, then rights are contingent on government, large S, and government can take them away and give them as it pleases. So when we talk a little bit in a moment about free speech rights or search rights or that sort of thing, these rights of life, liberty, property, which is our Constitution's way of putting it, are ones that come prior to government, and that government has to have a very high bar before it interferes with. So with that context, let's take a look at several basic constitutional principles. First, let's say a couple more words about federalism and state rights and what we mean by that word that I'm guessing most listeners will have heard and maybe used. Federalism is a system by which we mean that there is a large but not omnipotent federal government, and which has, as we know, 50 of our states, which have independent, separate rights to manage what goes on within their borders, independent of the federal government. There's certainly balance between the two. There are checks and balances among the two. But the reality is that all 50 plus that federal system, 51 systems of laws and governments, have a range of ways that they can interact with American citizens to protect them and exercise their power. But it's important to say this: the federal government has very limited powers in a pandemic. And maybe the central theme that we take up in this short webinar, but one that I think you've all experienced and wondered about, is just what exactly can the president do with his emergency powers? And what can't he do with his emergency powers? In a federalist system, the governors, frankly, turn out to have more power relative to a pandemic than does the president. You've seen the president move back and forth more than once on, I'm going to demand a shutdown, I'm going to demand an opening of all states. And then I think realized along the way that the states have very significant power to do as they wish with respect to the pandemic or an illness like this one. The federal government controls our ports, our airports, and our interstate system. So there are ways in which, under very significant difficulty, the president could exercise emergency powers, let's say, and close them down. The federal government, and again, I mean here primarily the executive branch, has the right not to commandeer manufacturing, but to direct it in particular ways. So you saw, for example, that some companies were given additional funding to produce masks. And in the context of that additional funding, the government became the first in line to get them when they were made. There's lots the president can do, but it's important to say that there's lots that he cannot do. And those state rights are immensely important with respect to a pandemic. Now, let me just say one last thing about federalism. The president can't control state borders. He might be able to control movement of cars and that sort of thing, moving in and out of them on an interstate. But as a general matter, the business of quarantine, state closures, police intercepting vehicles with license plates from other states to see whether they were planning on a quarantine, these are state level things. The federal government can, just to summarize number one, commandeer states or command state legislatures or executives to do any particular thing. So the bottom line is you're going to see very few national rules relative to a pandemic, whether they would involve masks, national shutdowns, or orders to reopen. Second, and maybe the most important component of this entire presentation, is to describe what the police powers that are possessed by the governors of the 50 states are, because those are the ones that have been used throughout this pandemic to do everything from close or regulate businesses, to keep people in their homes, to, as in many states, Texas most recently, compel people to wear masks in public places where social distancing is impossible. The police powers are the state powers to protect rights. As a straightforward thing, let's just simply say they're as easy as that. Governors and other state authorities, legislatures and judiciaries as well, have a broad range of authorities that fall under the category or the term police powers. Chief among those is to protect the health and safety of citizens. So, among your rights, perhaps the most important are to be healthy and safe. And the courts have consistently said that the state level governors, or I should say state governors, have very extensive, virtually unlimited power to enforce, for some period of time at least, whatever rules or regulations are necessary to protect health and safety for the citizens in those states. So let's start by reiterating these are essentially unlimited powers, and that is a very unusual phrase to use in an American government context. We think about checks and balances, we think about limited government, we think about enumerated powers and rights. It turns out that the police power possessed by state governors and primarily state governors, but by state legislatures as well, is extremely extensive. So the only couple of things that limit those police powers are the states themselves, that is, the powers have to be given to a governor by the state constitution, and those powers can be limited, perhaps, for example, in terms of the amount of time a governor can possess them. So states have the right to limit their own powers, and that's really an interesting conversation. And second, relative to your federal constitutional fundamental rights. So while the police powers are extensive, it is a very high bar over which a governor or a state legislature needs to go to deprive somebody of a fundamental right, life, liberty, or property. And we could probably, I think, in fairness, more generally say your Bill of rights. So walk away with this understanding. The police powers are very extensive, almost unlimited, and they are what give governors the powers to do almost all of the things that none of us have ever had done to us before in our lives. One interesting dimension here is that governors have found themselves as opponents of their own legislatures on occasion. Michigan's governor, as a for example, has rotated her orders through several different state statutes because her powers are limited by time. So when they ran out, she would use to make the same police power pronouncement a different state statute. So there's lots of different things going on here. In Wisconsin, we'll come back to this one in a moment again, the legislature sued, saying that the state health authority had gone too far in the exercise of its police power, and they prevailed. So while Michigan's governor has been very successful in saying, I'm going to exercise power that even portions of my state legislature don't wish me to, Wisconsin's governor was not. Third, let's mention that the law recognizes two very different contexts in which we live our lives. The first is public, the second is private. In public settings, there is considerable room for government to legislate and regulate behavior. So what I mean by that is in parks, forest preserves, sidewalks and streets, the places that are not owned by us, but which are traversed by us. So when Texas says you're obligated to wear a mask, they say it in public. And they have the power to do this because, generally speaking, the government has very extensive power relative to public contexts. Private contexts, by contrast, are ones where government has far less authority. Now, I encourage you to think of this as a spectrum, that is, with absolutely private at one end and fully public, let's say, in the hallways of the public library at the other. The spectrum starts with private settings like your own living room, where you are entitled to absolute authority with respect to all things. People don't have the right to say what they want, for example, in your living room. They don't have the right to do what they want in your living room. You own it and you can regulate it, and those rights don't apply. In the fully public context, on the other hand, those rights are very much more protected. So as we move forward and talk about employment contexts versus, for example, public parks and other areas where the government is asserting authority, let's be aware that in private contexts, the government power is much more limited. Fourth, we have two ways of thinking about the law in America. There is the civil law, which allows people to recover for negligence. These are lawsuits, to use sort of a common word, and they allow money damages. So when you hear about somebody recovering from a company or another individual dollar damages, you're hearing about a civil lawsuit. They are one way that we regulate behavior. And when we come to the portion of this presentation on where you work, let's suggest that the civil law might be a very important way that businesses are compelled to protect people's safety. There is, on the other hand, the criminal law. And here is where the government makes judgments to punish a person on the basis of their culpability or their wrongdoing. Murder one, kidnapping, robbery, burglary. But what I want to mention later on is failure to wear a mask or deviating from some regulation relative to the pandemic. We have seen very little effort to enforce criminal law relative to pandemic directives. I think as you're seeing things spike again, and as governments are confronted with the failure maybe of a more laissez-faire attitude to the virus, the possibility that criminal law could be applied, for example, to public settings where persons are required to wear a mask. It's a really interesting area, and I think it's one we're going to have to watch develop. Last kind of basic constitutional principle is the way courts will look at government efforts to regulate. Three things must be true, generally speaking, of federal or state regulations before courts will overturn them. That is to say, if these aren't true, those regulations are suspect. The first is that any regulation has to be related to a legitimate government purpose. It can't simply be pretexts for discrimination. Let me give an example. There was a point in time in San Francisco where there was the belief that the plague had come to town, and the local government, that is San Francisco city government, essentially quarantined the Chinese portion of San Francisco. When those residents sued, they said there is no government purpose here because there is no obvious way in which the plague is more present here than other places, and it is simply a pretext for discrimination. And the court agreed. So government has to have a legitimate purpose, and they have to demonstrate that the regulation is pursuing that government purpose, not simply that there is some effort to discriminate or otherwise harm people. Second, government regulations need to be narrowly tailored. That is to say, no greater restriction than is required to accomplish the government purpose. There have been a lot of people that have argued with respect to shelter at home and quarantines that those are not sufficiently narrowly tailored. We're new enough in this process that the courts have really not had an opportunity to measure whether that's true or not. They're giving enormous deference to governments at the state level, and in particular to governors. But at some point, the question might be, is there a way of more narrowly tailoring? Again, let me give an example. If it turns out, and it's pretty clear that we don't know whether this is true or not, that once a person has had COVID and recovered from it, they are essentially immune from getting it again. Think here of chickenpox. If a person had that set of conditions, would it be the case that you could continue to make all people shelter at home, including those who aren't at risk of either getting or transmitting the disease? I suspect a court would say, to the degree a person is prepared to say, here's evidence that I've had it, and here's evidence that I'm immune from it, that you couldn't include them in a continuing stay-at-home order. Third and finally, and I think this won't come as any surprise, the laws have to be consistently applied. That is, you can't say of one business or person, you have this set of rules, but To another group, you do not. Let me just give a sort of prosaic example that you've seen in this current pandemic. In a number of states, drive-in liquor stores were considered essential services and allowed to stay open, but drive-in church services were not. In at least one case from a southern state, the church filed a lawsuit saying if drive-in liquor stores are permitted, then drive-in churches must as well be, because there's no meaningful distinction between those two things, and they prevail. So regulations have to be applied consistently across categories, or they are going to be suspect and overturned by the courts. So let's turn then to where you live and say a couple of words about lockdowns, quarantines, gathering restrictions, and essential services and goods. And I think actually number 4 is in many ways the most interesting, because in many ways we've sort of given the answer to numbers 1, 2, and 3. Lockdowns and shelter-in-place orders that are grounded in the police powers of a governor to promote health and safety of citizens are absolutely enforceable, and theoretically, for whatever period of time it's possible to say, they produce health and safety for citizens. So it is entirely possible that states that have moved from out of phase 1, to use the Illinois language, which was shelter in place and lockdown, could opt to move back there if these spikes are significant enough. I think you're going to see resistance. I think you're going to see lawsuits. And the courts are going to have to address the question of whether or not going back is there a legitimate government purpose in closing down again. And I'll just say again, courts are extremely deferential to the judgments made by executive branches, governors and president, relative to health and safety. So lockdowns and shelter-in-place orders are absolutely enforceable. There's probably some point at which they are suspect because they are too lengthy, but in my judgment, we're nowhere near that yet. Mandatory quarantines. Theoretically, these are a bit more complicated because they might be accompanied by a criminal penalty for going out into public. So I mean here somebody quarantined because they've tested positive, who says they won't stay in their house. Clearly, government has the right to quarantine to prevent transmission. Some will recall that there was, in the Ebola crisis of a few years ago, a nurse who came home from serving in Uganda, is my recollection, who declined quarantine, and the police surrounded her house. This is part of the police power, and it is, assuming that there is a transmission possibility, absolutely enforceable. Third, restrictions on gathering. Michigan's governor sort of famously said you couldn't even gather with your own family in groups more than 5, or if it meant traveling to another place. Now, before that was litigated to a degree that courts had a chance to decide, is that narrowly tailored enough and does it really truly relate to a government interest? She eased off of that regulation. But let's say, again, the police powers are sufficiently unlimited and the courts are sufficiently deferential to them that it is very likely that any gathering about which a government official could make the claim, the health and safety of the public are advanced by enforcing this restriction, would be legal and supported and enforceable. Say a couple words about essential services and goods, because I think this is one of the places where there's been the most significant degree of pushback and where the courts have intervened a little bit in places where it's pretty clear that there was inconsistent application or something less than a genuine government interest. The worry with respect to governors declaring what's essential and what's not, either in terms of services, goods, or for that matter, people's jobs, is that it is enormously difficult to do this in a way that is consistent and narrowly enough tailored that it doesn't shut down, let's just say, the whole economy. So you've seen in states, for example, California, where pot dispensaries were essential businesses that were allowed to stay open, liquor stores as well in most places, but not ice cream parlors. That is to say, how does one make a judgment about what is essential and what's not, and are orders that make it possible to buy some kinds of food or other kinds of comestibles essential and others are not. In Michigan, you couldn't buy gardening supplies, but you could buy lottery tickets. Now, again, while it seems like it has been an endless period of time that we have lived with this virus, 3 months or thereabouts in the judicial clock of America is very, very short. So, as a general matter, we don't have many trial courts weighing in on the propriety of these essential services and goods decisions. And where suits have been filed, governors have frequently amended their orders to address some of the inconsistencies that were in them. This would be a pretty good place to say again, it's a good idea to give people the benefit of the doubt. One guesses that Michigan's governor wasn't engaged in outright discrimination when she talked about lottery tickets but not gardening supplies. She probably had a rationale. It may or may not have survived a trial court scrutiny, but she retracted from or retreated from it, and has continued to retreat a little bit on some of these issues. The bottom line is that because judicial branches are so deferential, even where on their face some of these restrictions seem inconsistent, too broadly tailored, or inappropriate, trial courts give a huge benefit of the doubt to governors. So, does government have, just to summarize in terms of where you live, a very significant authority to limit your behaviors and life? It absolutely does. And the likelihood that trial court decisions moving up through appellate court decisions limit that power, at least right now, is very limited. So for a minute at where you work, or doing this in a college context, where you learn, and mention four emerging sets of issues there. First, many employers are setting up conditions for employment, requiring, for example, that people coming into their building wear masks, that they take, I'll move my picture, that they take virus or antibody tests. So we don't have antibody tests widely enough available that employers are using this, but virus tests and temperature checks. Let's go back to what we said earlier. Private contexts produce a much greater level of ability to regulate people's behavior. So where an employer says you wear a mask or you don't work here, courts will support them. They have that right. For that matter, where a landlord says it in a commercial building, where an employer says you can't come to work without a virus test, I think it's almost certain that courts are going to say that's well within a private employer and a private setting's right to check. Where they take temperature checks, you've begun to see pictures of temperature checks at office building doors. Absolutely appropriate and absolutely within the purview of a private employer. So expect, as you go back to work, that you're going to see a lot of these things. And I'd argue that there's very little likelihood that courts are going to be sympathetic to the claim that being compelled to wear a mask, take a test, or have your temperature taken is something that infringes on your rights in a private context where you're working or you're learning, for that matter. Second, privacy. Here is a really interesting area because it feels to me like we are moving in a direction that may become problematic. There is a wide variety of technology available that may reduce virus transmission. Let's say it that baldly. South Korea has done enormously well in terms of tamping down the virus. One of the reasons is that their government mandated cell phone tracking apps that allowed them to surveil the entire population of the country and to shut down and move out people who were testing positive. I'm going to talk about the government context of contact tracing and technology in a moment. I think even in a context that is a private workplace one, though, there's some significant issues here. While the government is going to have a harder claim before, I should say, it's going to be much more difficult for government to do mandatory contact tracing. And I don't think it's possible that you're going to see it made the law. Workplaces have started to find a variety of ways to do this. Security systems have been converted into surveillance systems. They are, for example, with motion detectors capable of noting how many people are in a particular space. So I think there's going to be considerably uh, increased workplace surveillance. I think it stops with downloading an app on your phone. That is to say, compelling you to put even a private app on your phone in a private context like your office, or wearing a Fitbit or something that might be modified to measure temperature regularly, in my judgment, would go beyond what a private workplace employer would be permitted to do, given the range of ways that information might be misused. Third, I'd say a word about equal protection, because you're starting to see lawsuits with respect to those who are being compelled to come back to work, who want to return to work, who are being compelled to stay home, and who want to stay home. And what I'd suggest here is that the Equal Protection Clause of the Constitution, which requires essentially everybody be treated the same unless there's a rational or a compelling reason not to treat them the same, is going to be invoked with some regularity. Can we tell those who are 60 and older they stay home, and those who are younger than 60 they don't, because the risk for people who are over 60 is greater? That may very well be an appropriate, let's use the words, rational or compelling employer decision. It may work to the tremendous detriment of some people who very much want to go to work, but who are compelled to work from home. And it may also be the case that people are very much wanting to stay home, but are told you are not in an at-risk group or an elevated risk group, and you cannot in order to produce continued employment. It'll be equal protection that decides those questions, and employers are going to have to show that whatever judgments they make, if they do discriminate among classes of people, the old and the young, for example, is the best example, are ones that are based on a legitimate rationale, not simply getting old people out of the workplace or young people into it. Let's last mention, with respect to work, civil liability and lawsuits that might be filed against those um, who, because they bring people back to work, could theoretically be blamed for them becoming sick. I'll just mention that the first significant lawsuit like this has been filed, and it's by Las Vegas Strip service workers who sued the hotels along the Strip, alleging that they failed to keep them safe. And there's a variety of ways they say that was true when they brought them back to work. If I had to guess, there's going to be very significant activity in this civil liability area. People go back to work, find that they are positive testing, and then sue their workplace. Or for that matter, we're going to come to where you recreate in a minute, a restaurant or a bar, a park, or any other kind of place where they think they may have been exposed. The worry, of course, with respect to employment is that most of it takes place anymore in buildings that don't have windows that open and close. And because they're in ventilated systems where the disease can be transmitted very easily, could very well be infection hotspots. Having said that, we're going to see a lot of activity here. I think it's also likely that we're probably not going to see huge numbers of at least trial court verdicts, because the proof that being there caused your illness is right now immensely difficult to produce. That is, knowing how you were infected, by whom and when and where, and those are the bars one is going to have to get over in order to prevail in a lawsuit like this, is very, very difficult. That doesn't mean it's not going to cost employees a lot of money. I'm sorry, employers a lot of money to defend suits. I think it is. It doesn't mean that insurance rates aren't going to go up. They already are. The news has been reporting for a couple or 3 days that businesses are seeing increased premiums that reflect bringing people back to work who may sue after they become infected. And it doesn't even mean that there won't be some payouts or settlements to those who, if they are brought into the workplace, become infected. This is one I think, in addition to privacy, to pay close attention to, because reopening absolutely means that we're going to have to think through what are the guidelines, what are the standards of practice that businesses must deploy in order to open and protect themselves from civil liability. Let's say a couple words about where you recreate and then close with some final thoughts and observations. Are travel bans and travel limitations permissible? They are, other than to the extent that the federal government owns the interstate road system. So if one passes into any border in the Midwest right now, and many of you probably have, you've seen signs saying you're obligated to quarantine. Coming back from Michigan into Illinois, you'll see a sign that says the mayor of Chicago, which would be your first stop on your way into Illinois, requires a 14-day self-quarantine. Come back to the interesting question of how she could enforce it. Right now, it is voluntary. On the other hand, should things get worse, and it is a criminal violation to not self-quarantine, could just theoretically people be fitted with location devices? It sounds like science fiction, but one has huge police powers to protect health and safety, and coming into a state theoretically infected and not having any better mechanism for enforcing a quarantine, that could certainly turn out to be one approach. Last, let's mention as to travel limitations and bans and that sort of thing. Consistency really matters here. I don't want to sound like I'm picking on Michigan's governor, but she's gotten an awful lot of attention for a number of the things she's done. One of which was that people that came to Michigan could use kayaks, canoes, and self-propelled boats, but they could not use motorboats. She has retreated from that, probably because there wasn't a rationale for making that distinction that she thought courts would uphold. But that balancing of what advances a government interest versus what's inconsistent, not sufficiently narrowly tailored, and what's outside the police powers is an important thing to bear in mind. Worship and First Amendment rights have been in the news a great deal with respect. And I hope when I say where you recreate, and I include worship here, I don't seem cavalier about that. I mean, once you're outside your home and once you're outside your workplace, one of the major things that people seek to do is worship with one another. And churches have found themselves in a very difficult position because in many states, the lockdown applied to them overtly. And in some states, it applied to them uniquely. Let's say this, we'll go back to a thing we've said earlier. Where things are inconsistently, I should say, where rules are inconsistently applied, they are not enforceable. So New York this week lost a lawsuit filed by a coalition of churches and synagogues saying that the New York rule that allowed 25% capacity in stores and theaters and places like that, but specifically excluded churches for the same standard, a federal trial court judge ruled that that violated the Constitution, both under the First Amendment and in terms of the fact that it was an inconsistent application of a rule. Neutral rules will work. Had New York said 25% capacity everywhere, almost certainly that federal court would have enforced the rule. But to single out any particular entity, and in particular to single out one that has First Amendment protections, produced the opposite result. That is that regulation was struck. Last, let's just say this with respect to mask orders. We've mentioned them before. They are, and I guess I'd say from my perspective, oddly controversial. The science on them is clear. I know my friend Greg Ruthig has already presented, and my sense is that everybody who talks about the transmission of this disease concedes that masks reduce it. Because of that, mask orders in restaurants, hotels, theaters, or any other kind of place where you might recreate, whether public or privately enforced, are, I think, absolutely defensible, and the law is not going to permit people to decline to wear a mask. Again, the interesting question is whether or not states have the will to criminalize failure to wear a mask and to actually punish people if they don't. Could they? Yes. Will they? Entirely different question and a very difficult one. Let me just offer a couple things to the future. and then wrap up. I'm scheduled to do live question and answer, and I'm really looking forward to hearing what people's questions are in this area. But let me mention 5 things that I think we're going to see a good deal more work on. The first is how much contact tracing will there be, and who's going to do it? I've mentioned South Korea. They're not the only government that compelled downloading of an app, tracking people, and then confining them if they were infected. This is very problematic, I think impossible to do under our Fourth Amendment, which protects people from unreasonable search and seizure. And so, for the first time, I just want to mention 2 cases that the Supreme Court has decided that give us some guidance here. The first is called Carpenter, and it is a case that involved, I won't go through the whole facts, we don't have time, but the use of cell phone location data to advance a criminal prosecution by finding out where a particular person was and making him or placing him at scenes of crimes by subpoenaing his telephone records. Supreme Court said that that is not a thing that can be done without a warrant, and that there is an expectation of privacy in your cell phone location data. A second case, this is the Jones case, involved the placing of a physical GPS device on the bottom of a car of a suspected drug dealer. When arrested and when tried and convicted for dealing drugs, it turns out that one of the ways government obtained all the evidence was by placing this GPS without an active warrant under his car. And in what was a very interesting Justice Scalia opinion, they decided the case very narrowly. That is, placing the GPS device without a warrant on the car was illegal, but because it was a trespass. So what I suggest as we think about the Fourth Amendment and tracking is that government is going to have to overcome a very high bar to get past the privacy of location and what is effectively a trespass if they compel you to put a thing into your phone, which is your property. However, and let me give the other side, there is a special needs exception to the Fourth Amendment. That is, not all searches and seizures require warrants. Student athletes are tested for drugs because we have a special need to do that. If you're pulled over on the side of the road, you can be compelled to do a breathalyzer test and a field sobriety test, which are both forms of search, because alcohol diminishes in your bloodstream, and the search at that point is important. It is an unanswered and completely open question to what degree a pandemic produces a special need that would overcome Fourth Amendment protection, maybe even to the degree that contact tracing or contact tracking software could be downloaded. Among the questions in this area, I'll have to tell you, this is one of the ones that's the most interesting to me as somebody who's very much a privacy advocate and very interested in the law of privacy. Second, what about limiting the power of state and federal executives? There's been some movement in this area. Wisconsin, as I mentioned earlier, their legislature sued on the grounds that their state health department went too long and too far with its shutdown order, and they won. Now, they won because the state statute had elapsed. That is, the power of the health department had largely evaporated under state statute. And I think one of the things I predict going to the future is that legislatures, which have found themselves on the sidelines of this entire pandemic, are going to say, we've given the governors of our states too much power, and we need to be sure that these emergency or police powers are limited in terms of time and scope. And I can see a possibility where constitutions, the state constitutions, are amended to do that, or where state statutes are addressed that might also set better time limits. The federal executive, because he doesn't have enormous power, might be given more theoretically. Uh, this president has not exercised all of his emergency powers, but even if he had, they probably would have been surprisingly thin to most Americans. So while states might limit governors, you could imagine some federal law empowering a president further. Third, as we move toward a vaccine, I can imagine a reinvigoration of the question about to what degree government can compel a person to accept a vaccination. Things that intrude on the body are things about which courts are suspicious. Taking blood out or putting medicine in, courts have said requires a significant bar. Now, anyone listening probably knows that the states and the federal courts have almost all said, as a general rule, mandatory vaccination is an enforceable sort of thing. The penalties being that you can't enroll in school, for example, if you don't have them. However, everybody listening probably also knows that there are exceptions to those rules. Religious exceptions are one, and in some states, just simply a health exception. I don't trust vaccines is one. More than 50% of Americans say they don't want to be at the head of the line for a vaccination against COVID-19. This probably comes as a surprise, but many listening are probably saying we're rushing and moving so quickly toward one that you're nervous not about the concept of vaccination, but about the safety and efficacy of something rushed to market. So I think you're going to see some butting of heads and maybe some lawsuits involving the question of whether or not states can require a COVID-19 vaccination when one is available, or can the federal government do so at a national level? Two other quick ones to wrap up. There's been considerable conversation about misinformation and censorship of social media sites with respect to COVID-19. Now, I use the word censorship guardedly because private social media platforms can allow and prevent whatever speech on those vehicles they like. You do not have a right to speak on a social media platform. It's a private setting, to go back to that distinction. However, many of them have taken the view that there is a sort of quasi First Amendment right. That is, that they want to broadly protect the right to express opinions. As we record this, Facebook is facing a very harmful ad boycott because they will not more aggressively, I guess is probably the best way of putting it, limit hate speech. They want a broad range of opinions. Those on the other side want to be sure that those opinions don't go far enough that they perhaps produce violence or that sort of thing. Here, there has been a bevy of profoundly sometimes unreliable information about COVID-19. I think you're going to continue to hear a conversation about not just the degree to which, but the propriety of, more often than not anywhere else, social media sites taking the position that they are going to remove unreliable information relative to this in the interest of protecting health and safety. It's a much more difficult thing for a government to step in and compel any of them to try to censor information. I think you're probably not going to see a lot of that given the First Amendment obligations government has. Last, there's been a lot of questions about whether or not when businesses were closed with or as a result of government mandates, they should be entitled to recover from government because of the Constitution's takings clause. When the government takes something from you, let's say by eminent domain, they are required to pay you fair market value for it. The courts have been very hostile to this question, and I think for good reason. Takings involves a physical entering and possessing of a thing. So, for example, if a state commandeered a hotel and said, we are now going to use this in this national emergency to increase our bed space for hospitals, clearly this is a taking. Clearly compensation is required, but it's because there's a physical entering and control. Conversely, where a business loses, let's say, income because people are prevented from entering by government, there is, to the best of my knowledge, zero opinions where a takings clause recovery has been permitted. So I thank you for listening. It's been a pleasure to talk about this. There are so many interesting dimensions, so many unanswered questions, so many difficult balancing acts to undertake that I realize we've said a lot of things here are sort of maybe this, maybe that. boy, the next 6 months are going to be interesting. Knowing something about the law, I hope helps you navigate them. Thank you again.